Thank you for coming. Welcome to our inaugural 2017-2018 ConocoPhillips IRIS seminar. I want to begin by welcoming you on behalf of the University of Calgary and taking this opportunity to acknowledge the traditional territories of the Blackfoot and people of the Treaty 7 region in southern Alberta, which includes the Siksika, the Piikani, the Kainai, the Tsuut'ina, and the Stoney Nakoda First Nations. I would also like to note that the University of Calgary is situated on the land adjacent to where the Bow River meets the Elbow River, and that the traditional Blackfoot name of this place is Mohkinstsis, which we now call the City of Calgary. The City of Calgary is also home to Métis Nation of Alberta Region 3. So welcome everybody to this great topic. We started off the year from the Center for Corporate Sustainability looking at regulatory questions. Who was here for the lunchtime event downtown with Gaetan? Was there anybody? A couple? Okay. So we're going to lead from that, and today we have a speaker. She's the Associate Dean of the Faculty of Law. She is also an Associate Professor there. She's an affiliated faculty member of the Canadian Institute for Resource Law, the CIRL, and they have great events on Saturdays too, which they call Saturday Morning at the Law School. If you haven't gone to one of those, there's great topics there as well. She got her BA at the University of Saskatchewan, has her LLB from the University of Alberta, which is okay. But then she saw the light and got her LLM at the University of Calgary, where she specialized in natural resources and environmental law. She's here to talk to us about the Alberta oil sands past and present. She did a report in 2007, and she's here to update us a decade later. Please join me welcoming Nikki Nicolaou.
Thank you. Thank you for coming. Thank you, David. And Chanel, I want to thank you. You helped me make my slides prettier, fancier. So that's good. And I would at the outset like to thank the Alberta Law Foundation. Both, David mentioned that in 2007, I conducted a detailed research on the regulatory framework at the time for oil sands development. Both that project and the update 10 years later was funded by the Alberta Law Foundation, so I want to thank them for the funding for both of those projects. Back in 2007, for some of you who might recall, there was quite a bit of intense development. Alberta was booming. There was within the span of 4 months, there was 3 oil sands mines that had been approved. So it was really a time of intense development. Today, of course, given the economic climate for oil and gas over the last few years, the development has slowed down. It's not what it was anticipated to be, but, and I'll put up some statistics in a minute here, there still is development, it still is ongoing, and it is expected to continue at a fairly steady pace. So what am I going to talk to you about today? Well, the first thing is just to set the context a little bit. Now, a lot of you may know what oil sands development is and what it looks like, but it is important, and I'm going to put up some pictures here in a minute, for us to talk a little bit about the impacts and the scale of these developments. Because ultimately, trying to get our minds around the regulatory framework really depends on getting our minds around those impacts and the scale of the development. So I'm going to start off with a little bit of a oil sands 101. I'm not an engineer, so it's not going to be detailed. It's going to be very much an overview. And then the next thing I'm going to do is I'm going to outline the 3 key deficiencies in the regulatory framework that I identified in my research in 2007. And then, of course, I'm going to update that research and ask what has changed with respect to those 3 deficiencies. Okay, so what is oil sands development and why do we seem to care about it so much in this province? Well, the oil sands are sand deposits that are located in the northern part of the province under the boreal forest, and those sand deposits contain vast amounts of crude bitumen. The area in which the deposits are located, called the Athabasca, Peace River, and Cold Lake regions of the province, has been estimated to be roughly 6 million hectares of land, and that's an area comparable, I'm told, to the size of the state of Florida or to the country of Ireland. Depending on the estimate, Alberta contains the 3rd or the 2nd largest oil reserves in the world, and a majority of those oil reserves are in the oil sands. Some estimates are that the oil sands represent more than 97% of Canada's remaining proven oil reserves. The oil sands themselves are a mixture of sand, clay, water, and bitumen. The bitumen in the oil sands is, of course, very heavy, very thick, and so it must be treated to a great extent in order to make it into usable fuel. Technological advancements have made the development of the oil sands possible, and those advancements continue to be furthered on basically, every decade. There's new advancements that are promoting and helping with this development. About 20% of the oil sands are close enough to the surface to be mined. There are right now about 9 oil sands mines in the province, and I believe there are 2 more in the works at the project approval stage. So you'll see from this photo on the slide that oil sands mines require the boreal forest to be stripped, and then they require the land to be stripped using basically large trucks. It's very much a shovel truck type of operation. And then the bitumen is sent for processing to remove the bitumen from the oil sands. There's obviously a lot of energy and water used in this process. But about 80% of Alberta's oil sands are too deep to mine, and so the bitumen is recovered in situ. And this is done through techniques that use wells, the drilling of wells to inject steam into the underground formations in order to heat the bitumen and loosen it from the sand. Again, these operations clearly use a lot of water and a lot of energy. In situ operations are not as awe-inspiring as the oil sands mines, and so probably that's why we don't often see pictures of in situ operations in the news. But here is an aerial picture of what one looks like, and in fact there is more in situ development of oil sands in the province than there is of oil sands that come from the mines. About 60%, we have about 60 projects right now in Alberta on stream with in situ oil sands development. So just to give you a quick sense of how big the resource is, the estimates are that there's about 315 billion barrels of ultimate potential. And in 2016 in Alberta, crude bitumen production, which includes both mined and in situ, totaled about 2.5 barrels a day, and it's projected that by 2025 that amount will go up to about 3.8 million barrels a day. So why are the oil sands often in the news? Well, sometimes of course it's because we want to highlight the economic benefits of the development. Oil sand companies of course pay royalties and taxes to the government, which end up benefiting all of us as Albertans. And these operations, of course, provide jobs and all sorts of economic spin-offs. But more often, oil sands operations are in the news because of their environmental impacts, and in particular, with respect to the impacts on the Indigenous peoples in the area. Just looking at the slide here should give you a sense of what we're talking about in terms of impacts. There are impacts to the air, to land, to water. And just to give you a sense of what some of those impacts that the regulator typically has to review and manage with respect to these projects, I'll just list a few here just to give you a sense of what's required. So there are air emissions, toxic emissions of course, but also greenhouse gas emissions. And lately greenhouse gas emissions has really been an area that has been very, very difficult for oil sands developers to deal with as far as some of the media attention that they're getting, in particular with the pipelines that are proposed to move oil sands development to market. So greenhouse gas emissions, and I should say that the oil sands is considered to be the greatest emitter of greenhouse gas emissions in the province today. Then there are impacts on aquatic resources, both in terms of water quality and quantity, on fisheries, on fish habitat, aquifers, wildlife, birds, public health and safety, We need to make sure that the waste is properly stored and contained. Some of you may have heard about tailings ponds with respect to oil sands mines. There's noise, dust, traffic, impacts to other activities in the region, and impacts, socioeconomic impacts to people living in the region, and potentially health impacts. So why did I go through that? Because it's important for us to understand that we're talking about a lot of impacts. There are a myriad of different impacts that have to be managed and mitigated. And in addition to the ones I've listed, there are the cumulative impacts of all of those other things sort of working together on the landscape. So it's important for us to keep this context in mind, I think, when we get to the regulatory framework. One of the general themes that you're going to hear me talk about today is complexity. So in 2007, one of the things I concluded, which I'll go through in a minute, was that the regulatory regime was very complex. Well, we've made strides and it's a bit better, but it still is complicated and complex. And a lot of that complexity comes from the very nature of the development itself. So the legal regulatory framework. Added to the fact that the nature of the development itself is complex is the fact that in Canada we have two levels of government. Constitutionally, the federal and the provincial government have been granted jurisdiction over distinct matters. And so sometimes, even though the bulk of the legislation will be provincial, there will be federal legislation that applies and there will be federal jurisdiction involved. So for example, the Fisheries Act is an act that often comes up in the context of oil sands. The other one, of course, is the Canadian Environmental Assessment Act. So for large oil sands mines, the federal government is involved under the Canadian Environmental Assessment Act, which is why sometimes you'll hear about joint panel reviews reviewing some of those mines because it's a joint review between the province and the federal government. The other thing that makes the regulatory framework so complex, the current framework, is that what we have in Alberta is legislation that deals with different stages in the development process. So the first stage, of course, is exploration. An oil sands operator, even before it buys the mineral rights, will want to explore to see if it's viable for development. Then there is the mineral rights disposition stage, where the Crown disposes of the rights to work those oil sands minerals, to develop them. Then there's the stage where the company has to obtain access to the surface of the land. And most of the land that's involved in oil sands operations in Alberta is public land. Then, of course, approvals have to be obtained for the actual operations. Approvals, licenses, permits, all sorts of authorizations for the actual construction and operation phase. Then there's the phase of getting the oil sands to market, so the pipeline stage. And then, of course, reclamation and remediation, which requires the operators at the end of the production to clean up the operation and return the land back to equivalent land capability. So what we have in Alberta is legislation that applies at each of these different stages. And so this, just the sheer magnitude of dealing with these different stages means that the regulatory system is necessarily going to be complex to a certain extent. So, key problems in 2007. Back when I did my review of the oil sands regulatory framework, I concluded that there was three key sort of higher level, there was obviously a lot of little issues and problems at the level of detail, but at a higher level, we had a real problem because we didn't have plans, we didn't have detailed policy, and oil sands was occurring at such a rapid rate. Even the regulator at the time, the Energy and Utilities Board, was commenting in its decisions that it was finding it difficult to decide whether or not to approve some projects because it did not have regional land plans or specific policy direction from the government in terms of what acceptable limits of development would be in the region. So that was one of the first key problems. And of course, many commentators, environmentalists and others, have talked about the need for regional land use planning in order to properly address cumulative effects. The thinking is that we can't properly address cumulative effects without a regional approach. If we continue to try to deal with things on a project by project basis, we're not quite, we're not getting there. There was also complexity and a lack of transparency in the regulatory framework in 2007. And I'll get into more detail on this in a minute. But basically, at the project approval stage, there was 3 different decision makers involved. And so both industry and the general public, stakeholders, were finding it very difficult to navigate through this process. There was overlapping mandates and sometimes inconsistent decision making. And so there was a real lack of transparency and accountability, at least according to commentators at that time. The third problem was, and this relates to the complexity and lack of transparency, is that there were issues around public participation. So update to 2017. The first issue that I identified, the problem area, was that we had a lack of regional land use plans. Well, since 2007, the Alberta Land Stewardship Act has been passed, and the government has committed itself to integrated resource management. Scholars, of course, have argued that integrated resource management is the only way to properly address all the social, economic, and environmental costs and the impacts of multiple activities on the landscape. So in 2009, Alberta's Land Stewardship Act was passed, and it sets out a process, and I should say that this act is revolutionary, quite frankly. It's one of its kind. Still, other jurisdictions are studying it. When it was passed, it really was, Alberta was seen to be sort of on the leading the way in terms of integrated resource management. This act, otherwise known as ALSA, sets out a process for regional land use plans to be developed in the province. And in 2012, a regional land use plan was adopted which covers most of the oil sands regions, and that is called the Lower Athabasca Regional Plan, or colloquially, or using an acronym, as LARP. There are 3 management frameworks that have been passed under the LARP. One of them deals with tailings management, another one deals with certain air emissions, and another one deals with surface water quality, both in terms of quality and quantity. And the LARP does set some limits. There are some upper thresholds that can't be exceeded, and if they are exceeded, the companies are given warnings and are required to adjust their operations. So the LARP is definitely a good thing. It's a start, and it's definitely better than what we had before, which was no regional land use plan. But the reality is, and some of you, have probably read about this, commentators and critics have said that the LARP doesn't go as far as it needs to go. It's not specific enough. It's not comprehensive enough. There's a lot of impacts that aren't dealt with. And moreover, it's not entirely clear what happens when those triggers or thresholds are met or are exceeded in terms of how does enforcement happen. As well, a recent government-led report found that the LARP is failing Aboriginal peoples in the oil sands area in terms of protecting their Aboriginal rights and interests. So there still is a lot of work to do with respect to regional land use planning, but in terms of what I had concluded in 2007, which was that there was a lack of plans, at least we do have a plan now. The other area that wasn't addressed in any significant way in 2007 was climate change and climate change impacts, greenhouse gas emissions from the oil sands operations. In 2007, Alberta has launched its climate leadership plan, and included in this plan are a couple of statutes that apply directly to oil sands operators and are designed to reduce greenhouse gas emissions from their operations. Again, these statutes are far from perfect, and critics have basically criticized the statutes in particular for failing to place an absolute cap on greenhouse gas emissions, both at the facility level or at a regional level. So very recently, though, the Alberta government passed what's called the Oil Sands Emissions Limit Act, which somewhat arbitrarily, according to some commentators, imposes an emission limit of 100 megatons per year for the entire oil sands industry. Today, oil sands emit about 70 megatons per year. We don't know exactly how this emissions limit is going to operate in practice. The regulations are still being developed, and until we see them, it's impossible to properly assess the impact of this legislation. The other big area that I considered, or the big conclusion that I reached in my 2007 review, was that the system was unduly complex. At the time, as I said, there were 3 key players involved in the project approval stage, and they were each operating under different pieces of legislation. And those were Alberta Sustainable Resources Development, the Energy and Utilities Board, and Alberta Environment. And there was often duplication in the process. So the EUB had to do its own environmental assessment, but then Alberta Environment also had to do an environmental assessment under its legislation. Or industry had to report on emissions to multiple different regulators. So at the project approval and operation stage, there was this situation of overlapping mandates and complexity in terms of who the decision maker actually was and how the decision makers coordinated and integrated as between themselves. In terms of mineral rights disposition, the mineral rights to oil sands are granted by Alberta Energy under the Mines and Minerals Act, and that continues to be the case today. So there's been a real change in terms of that project approval stage, though. In 2013, the Alberta legislature passed a statute called the Responsible Energy Development Act, and this statute abolished the Energy and Utilities Board, which at that point had become again the ERCB, but that's another story. In its place, the REDA, as we call it, created a brand new entity, the Alberta Energy Regulator, and it made the regulator responsible for all aspects of oil and gas development for the entire life cycle of energy projects, from exploration all the way through project approval, surface rights disposition, project approval, operations, and then to final abandonment, reclamation, remediation. So it created a one single regulator, a one-stop regulator for everything in terms of the operation from start to finish. Why did the government bring in the single regulator? Well, a task force had been struck, and there was a lot of consultation, and it was found that there was a need to streamline and clarify the regulatory framework, that there was a lack of coordination and a lack of transparency. And the government at the time also concluded that a single regulator would improve public engagement and accountability. So how does REDA do what I just said it does? Well, it does so by giving the Alberta Energy Regulator authority under both resource-specific legislation, so legislation like the Oil Sands Conservation Act, but also giving it authority under the general public lands and environmental legislation in respect of energy activities. So whenever an energy activity is involved, any water approvals or air approvals that are required under the Environmental Protection Enhancement Act are now given by the Alberta Energy Regulator. But moving to the AER was not just a change in process. In fact, the legislation contained a significant amount of changes in substance to the new entity. So it changed the nature and the setup of the energy regulator. We used to have a board whose members made decisions both on applications and with respect to hearings. But the AER is set up differently. Routine applications are dealt with at the staff level, so officers of the regulator make those decisions. And then anytime there's a hearing, there's a separate roster of people who are listed as hearing commissioners, they're not board members. And the chief hearing commissioner will choose from this roster to select people to sit on the hearings. These hearing commissioners are not appointed for fixed terms, and they are appointed at the pleasure of cabinet. Many commentators have criticized this move to a hearing commissioner process, saying that this has led to a loss of expertise that had been accumulated or that could accumulate with more permanent board members over the years, and as well a loss of independence because there's no direction in the Act in terms of who these hearing commissioners are going to be, how they're going to be appointed, how they're going to be chosen for a particular hearing. The other big concern with the change, and the jury is still out on this, is whether we have lost some important checks and balances in the system. When we had a multi-regulator system, yes, it was complicated and cumbersome, but it still provided some checks and balances because you had more than one regulator. Giving all the power now to a single regulator, obviously, critics have said is basically creating a monopoly situation, and we've lost some of those checks and balances that were inherent in the system. So the question then is the system now less complex because we have a single regulator? Well, there are certainly some efficiencies for sure. We have a single regulator, so oil sands operators and the public, in theory, should only have to deal with one entity to, for all their approvals or all their licenses and permits. But if you're actually trying to figure out what approvals, permits, etc. are required, you still have to go to a myriad of legislation, regulations, guidelines, policy documents. So it's not as though we created an Oil Sands Development Act where we can go to and find all the answers we want. The Alberta regulator administers and gets its powers from a whole series of acts, the acts that I set up on the slide previously. So there still is, of course, complexity in that sense. There's also complexity because the AER under the RETA is given very broad discretion, more discretion than even the previous boards had. So it's very difficult, and I'm going to go through this in a minute. It's very difficult, for example, to find answers to questions like, you know, am I entitled to a hearing? Am I entitled to costs? Because ultimately the provisions grant the AER such broad discretion that it's very difficult in any given case to make a meaningful determination. So this leads me to the last topic for today, that of course I'm just going to briefly touch upon, and that is public participation with respect to oil sands development. So why is public participation important, especially in the context of development that occurs on public lands, just like oil sands does? There are, of course, a number of reasons for why commentators and scholars have argued for the need for public participation in the context of development on public lands. Some of these reasons are that we need to ensure transparency, we need to ensure accountability, and also it is thought that having people who are informed and have expertise, having them involved in the process will make for better decisions. It's also been justified and argued that the public nature of both the oil sands resource and the land and air and water that's involved requires and mandates some form of public participation. And undoubtedly, the government believes that public participation is important on a sort of broad scale in terms of oil sands development, because prior to a company applying for an approval for an oil sands operation, the AER does require very broad stakeholder consultation to occur. And this has to include environmental groups, local municipalities, of course, Aboriginal peoples in the region, and so a broad-based public consultation process. And that has not changed since 2007. But the one problem identified in 2007 was that there was no such consultation occurring at what some commentators believe is actually a critical stage of the process, and that is the mineral rights disposition stage. By the time things get to the AER, the company has already acquired the oil sands rights from the government. And so often it is thought that all things being equal, that fact will tilt the balance towards approving a project instead of not approving it. The other problem was that the test at the time for someone to have standing to be able to be heard at a hearing in front of the board was very narrow. The test was that someone who was directly and adversely affected by an application could get a hearing before the board. The problem with public lands, of course, is that there is often not a landowner involved that we can point to say that person is directly and adversely affected. And the way that this test was being interpreted basically meant that environmental groups had to show that they had members who were being actually impacted both in terms of some sort of legal interest that was involved, so if they had a recreational lease or if they were living or working near the proposed site. And then there was the problem, of course, of getting costs to intervene. Of course, how many people are going to be involved in public hearings if there's no sense of being able to get costs for that involvement? In 2007, the provision was that an intervener, as long as they had an interest in the land that was involved, that they were entitled to get costs. Now again, with respect to the oil sands regions, it's often hard to have a landowner. These are public lands. And so there was a number of cases back in 2007 where even the local municipalities were denied costs by the EUB at the time. So what's changed? Well, rather than moving to a more expansive approach to public participation, as many commentators at the time thought, a lot of commentators thought, okay, we're getting a new energy regulator, let's open this up and deal with some of the problems with the standing test, with the intervener cost provision. The RETA actually narrows the situation. So previously, there was an actual standing right for somebody who was directly and adversely affected by a proposed development. They had a right to a hearing. The RETA now takes away that right. There is no right to a hearing anymore. And it gives the AER broad discretion to deny a hearing even to somebody who is directly and adversely affected. And the reasons that the regulator can give for doing so include things like the objection raised by the person has been addressed to the satisfaction of the AER, or any other factor that the regulator considers appropriate. So far, several environmental organizations and even First Nations groups have been denied hearings before the AER. And this has been so even if they've been able to establish that some of their members that they have a legal interest that is being directly and adversely affected. From my review now, in 2017, the AER is simply not holding a lot of hearings. Now, part of that may be because there's been a downturn in terms of the oil and gas activity, but still, there are tens of thousands of applications that have gone before the regulator since it was proclaimed in 2013, and the number of hearings is steadily declining to last year, there was, in 2016, there was only 4 hearings that were held by the AER. And this is not just in the oil sands, this is for all oil and gas activity. And the same situation exists with respect to granting costs to participants. And in fact, the AER no longer calls its decisions on participation standing decisions. They are now called participation decisions because, as I said, the standing right has been removed. So with respect to costs, the legislation grants the AER broad discretion to not grant them, even if a person is directly and adversely affected. So ultimately, there's no certainty, as I said, or predictability to anyone who might want to participate in the process. It's very hard looking at the legislation to try to determine whether, what are my chances of getting a hearing, and then what are my chances of getting costs if I was to participate. The other problem is that at the Court of Appeal level, so for those of you who may know, decisions by the Alberta Regulator can be appealed to the Court of Appeal, but they can only be appealed on questions of law or jurisdiction. And the case law at the Court of Appeal level is very confusing and complicated. And what's needed first is for somebody to get leave from the Court of Appeal to be able to actually appeal the decision. And at the leave stage, we have decisions from the Court of Appeal saying that this question of whether somebody is directly and adversely affected is a question of law, and so it's appealable. But then we have other justices saying that it's actually a question of mixed fact and law, and so there's no avenue to appeal that decision. So it's a very cumbersome, complicated situation. The other thing I would note is that the regulatory appeals, there is a provision in the RETA for somebody who is directly and adversely affected, who did not participate at the hearing, or even if they did, to bring an appeal. And it's called a regulatory appeal of that decision. But that regulatory appeal is internal now to the AER. In the past, there was an opportunity for people who were directly affected to go to the Environmental Appeals Board, which was a separate independent board, and have the appeal occur there. The Responsible Energy Development Act removes this and creates an internal regulatory appeal to the Alberta Energy Regulator. So you can imagine that a lot of commentators are saying, again, we've lost this check and balance that we used to have in the previous system. So moving forward, just a few concluding comments. What's good about the single regulator? Well, obviously there are some efficiencies. Everybody now knows that for everything dealing, other than the mineral rights disposition stage, for everything else, it's the Alberta Energy Regulator who's the regulator. And so industry knows and the public knows, and there's no longer this requirement to deal with Alberta environment or to deal with, at the time, what was sustainable resources development. But what's bad? Well, streamlining and complexity, of course, shouldn't come at all costs. And as I said, one of the big concerns, and the jury is still out on this, is whether we have lost some checks and balances in the system by moving away from a multi-regulator system to a single regulator. And I had done a literature review as part of a separate project, and from what I found in that review, there really wasn't any magic to a single regulator. The reality is that all the issues around accountability and legitimacy and public participation come up in both systems, whether it's a single regulator system or a multi-regulator system. We definitely still have public participation issues that remain in the system. And with respect to cumulative effects, how are we doing in terms of managing? Well, at least we have a plan. We have the LARP, we have a regional land use plan, and we have legislation that mandates the creation of those plans. But from what commentators are saying, right now anyway, this is just a first step. The plan doesn't go far enough, and cumulative effects are not properly being managed. And we still, just a quick review of the AER website, you can see that applications are still proceeding on a project-by-project basis. Now, part of this, I was interviewed earlier by two Huskane MBA students, and we talked about cumulative effects management, and the reality is, and as I said, that's why I wanted to put those slides up initially, this is a complicated development to try to manage, right? So it's not just the cumulative effects of the project itself, but also the cumulative effects of that project in combination with all the other projects on the landscape. And increasingly, we're finding that we just don't have the baseline environmental data that we need to have to properly manage these effects. Lastly, I think the system is still complex. I think it's still complicated. We don't have an Oil Sands Development Act. We still have to go, yes, it's the AER, but we still have to look at all these different pieces of legislation and different regulations under them and different policy directives to try to understand what's happening. So the complexity may be less than it was in 2007, but there still are some, it still is a complicated system. Thank you. Sorry, I just sort of ended there without a big splash.
It's okay. You are a lawyer.
I was just so happy to end on time.
Great. Thanks, Nikki. So now it's time for the Q&A portion. If you have any questions, if you could raise your hand, because we have two people with microphones that are roving around. We'd love to have your questions. So we have one over here, Chanel, and one at the front here right after Sherry. We do have a bit of time. In the meantime, while we get the microphone to our speaker, just want to note that you have a printed version of all our events for this year, both Enbridge Research in Action, ConocoPhillips, and where they are. Our next one will be on November 29th, so it's coming up fairly quick, on Indigenous entrepreneurship, and we're doing that in collaboration with the Hunter Hub, the newly established Hunter Hub. So your question, please.
Thank you. I was wondering if this lack of public participation, can you somehow tie it into a human rights issue? I know there's a bill that is going forward for a right to a healthy environment. Would that have any impacts on these issues?
Well, that's really interesting because another project that I've done way back in the day was on human rights and environmental impacts. And so the ability to use human rights legislation in Canada in particular would be the Charter of Rights to make a claim that these environmental impacts are impacting our health, our well-being. And the reality is, from the research that we conducted, and this was it wasn't just me involved in the research, was that the only ability in Canada anyway was through Section 7 of the Charter, the right to life, liberty, and security. We don't have, unlike some other countries, we don't have a right to a healthy or clean environment, or a right to health even, in our Constitution. Some other countries have it, and I think what you're talking about is a bill to bring that in. Now, that wouldn't probably be a constitutional change. It would probably be a change. Are you talking at the federal level, or Yeah, over the years, there's been various movements to try to get an environmental type of Bill of Rights. And some provinces, actually, some territories, Yukon, in its environmental legislation, does have a right to a healthy environment. But the reality is those provisions have not proven to be they haven't proven to have a lot of substantive bite. They tend to be sort of aspirational ideas. But in other countries, we are seeing people use, and I don't know if some of you know, but a few years ago, there were landowners in Alberta who were arguing Section 7 of the Charter. And there was a few decisions that had gone before the EUB. They ended up, one of them went to the Court of Appeal. In the end, the claim wasn't decided on the Charter issue. But the argument was exactly what you're saying, that the impacts from this facility or this activity is impacting my health.
Good day, Nicola. Our group spent $300,000 20 years ago to look to see what was wrong with the tar, and we call it tar salts because it's salts in between two layers of water. And if we have a cleanup solution, who's going to pay for that? Is it the government? Is it going to be the oil and gas guys? And in the 10 years that you first did this study to now, how big has the tar sands gotten since then? So it keeps on growing and growing. So I would say, well, why not just have these guys clean up their mess before they let them go in and continue producing?
Well, and that's an argument that some members of the public have made, is that why are we approving certain projects when we don't have, I mean, you mentioned reclamation, you mentioned cleaning up the mess. With respect to tailings ponds in particular, the technology is still being developed. We don't actually have full-blown technology that's going to clean up those tailing ponds for sure. And still, the regulator has been approving the projects. So some people would say, why are we doing that? Why are we allowing it? Well, I think the short answer is the cost-benefit analysis, right? That the costs are thought in the public interest. We need the economic, benefits from the development, and the way we need to balance that economic case is to try to mitigate the environmental impacts as much as possible. So with respect to reclamation, one of the things that's happening now, which wasn't happening in 2007, so I'm glad you asked these specific questions, was the regulator is requiring, and under the tailings management framework as well, it's there, progressive reclamation. So it's requiring operators to progressively reclaim and clean up and not wait until it's all done and then clean up. So there's progressive reclamation. And there's also, with respect to oil sands mines, been a security reclamation fund that's been set up. So oil sands mines operators have to pay into this fund to secure money for the ultimate reclamation. Now, whether there's enough money in the fund for how much it's going to cost at the end of the day, we don't know. And a lot of commentators are saying that, we may be left with a legacy to clean up.
Thank you very much for your presentation. I've sat on a couple AER committees lately and was part of one as an ENGO when we wrote Directive 85, which is the fluid tailings. My question actually is about the transformation to and achieving regulatory excellence. Cogliani from Penn State did a review of the AER and is wondering if you're aware of it. And
I'm not. Can you tell me about that? And unfortunately, I can't hear you very well.
I'm sorry. I've got his book here from Cogliani. You can look at it. Just an update. They are starting with the cumulative effects. There is area-based projects now, so it's more than one project. They're going into area-based. So the area around Fox Creek, for example, is their pilot project with the cumulative effects management.
Okay, good.
So, yeah,
Thank you. Yeah, I'd be interested in getting that. I'll write that down after.
Penn State was hired to review the AER because they were going to transform to a world-class regulator. And they spent a whole bunch of money, and the multi-stakeholder engagement advisory council was formed and a couple of committees and Directive 85, back to the tailings ponds one, it was the first time they actually used a multi-stakeholder process to develop the directive. And it was a very small part was the public participation or the community monitoring part, but at least we got it into the directive.
Okay, well, thank you. Thanks.
Thank you for the presentation. I have a comment and a question, and the comment I have is looking at the cost-benefit analysis that you alluded to. It seems to me if there was a real business case for oil sands development to this extent, they should be taking into the costs that they are externalizing to communities and environment. And it seems like that isn't happening. And as the gentleman over there mentioned as well, is what are the time frames for reclamation or remediation of these landscapes, because the cumulative effects over time is going to be just dominoed at a watershed scale and beyond that. And the other question I have is with the recent signing of the United Nations Declaration of the Rights of Indigenous Peoples, would there be articles under that that would trigger some better improved consultation processes with regard to Indigenous communities that are so impacted by these developments?
I might have to turn over to a colleague for the answer to that second question. With respect to the first question, That's been a real problem in the legislation, is that there are not hard and fast deadlines for reclamation. So what the regulator has been doing is imposing time limits and, for progressive regulation through the approvals. Tailings ponds, for example, under the management framework, under the new directive, they have to be reported on and some sort of movement on cleanup every 10 years. So, but you're right, it's definitely a problem. There has not been, because the idea has been, we don't want to stop production. We can't really tell them exactly when it's going to end, right? So that has definitely been a problem. With respect to Indigenous peoples, unfortunately, that's not my area of expertise. And you'll notice today I mentioned Aboriginal peoples, but I didn't mention the duty to consult and accommodate, that that the government is constitutionally mandated to provide First Nations people. I don't know, David, if you
Yeah.
want to take
So
this question?
We do have a lawyer, I want to say, that is a researcher in this area, so we'll have him say the final word.
Yeah.
And I want to
Thank
mention
you.
that both Nikki, Alistair, Lucas, and David are here after the event for a few minutes if you want to approach them with some of this.
Thank you.
You have the last word.
With respect to consultation, the Alberta Energy Regulator is statutorily barred from conducting consultation and accommodation. What's happened is the Alberta government has organized a separate office within its own office, and they will tell you who do you want to talk to, how long you get to talk to them, and they will say, oh, you've already done what needs to be done. And then they will advise the AER, this is the only direction under Section 69 of RETA, right, as to, oh, you've satisfied your consultation obligations. The problem, of course, is that the Alberta Energy Regulator is a constitutional decision maker, right? And so they can't get out of that, right? The last point too is the Lower Athabasca Regional Plan was the first regional plan developed. Originally the drafts were, take out some of the oil sands. And then when it went to Cabinet, and Cabinet, by the way, is the only one that can approve it. So all the recommendations from these committees and stuff like that are protected by Cabinet secrecy. You can't find out what's going on. And basically, they described, one of the AER, in a moment of candor, said, it's a blueprint for the industrial oil sands development. So it's a huge issue, and it is a big problem. Now, the one review of LARP, which people were talking about, and I think you mentioned it, it doesn't have any effect. It's just a recommendation to the government, and there's been no government action. And in terms of LARP, it also has a provision that says, even if you don't have any of the frameworks in, right, you still have to make a decision based on the LARP as it exists then. And so since 2012, we've been looking for a framework on biodiversity. Not happening. So anyway, sorry.
Awesome, thank you. I see your hand up. Is it a quick comment or question? We are at time, but if you make it 30 seconds or less, I'll give it to you before we wrap things up tonight.
I think I deserve the question because I'm an engineer and maybe there's not to me. A couple of things. It seems to me that computational methods and efficiencies are improving rapidly as a technological revolution, and that's allowing us to make inferences we previously couldn't. And for example, I'm looking at the Niger Delta study that was recently published on human health impacts of oil spills in the Niger Delta, which had some stunning insights on premature deaths and the like. I'm also seeing some of the climate change technologies are moving into the sphere of monitoring and emissions management. And again, I'm seeing insights on emissions that previously were not available to us as engineers. So it seems that technology is moving at a much faster pace than regulation can keep up with. So can you give me an example of jurisdictions or areas of technology where that's happened and how regulatory regimes respond?
in 10 seconds or less. And we can continue this conversation afterwards.
We can. I think the tailings ponds issue comes to mind. I think, back in 2007, there was basically, I'm not an engineer, from what I read, there was no known technology to remediate the tailings ponds. Obviously, technological advancements have occurred, they're occurring, and so, there's things happening. There's a lot of experimentation and things happening, and oil sands companies have, back in 2007, there had been no reclamation certificate granted to any company, and Syncrude has since received a reclamation certificate for part of one of its sands wells. So you're absolutely right. Technology is driving a lot of this, which is why, again, to answer the question of why approve something before we've got the technology, well, the idea is that we're gonna get the technology, right? We're gonna incentivize companies and operators to work to try to deal with it. So, okay.
So I'd be remiss if I didn't plug in COSIA with their EPA on tailings as well in some other areas. So with that, I want to thank you, Nikki, for your time, for sharing. She is going to stick around, so do come up. Alistair and David Laidlaw will stick around a little bit too if you have questions for them. And please fill in your review cards of the session and give us some ideas, and we hope to see you on the 29th. So with that, join me in thanking Nikki. Good for you. Thanks again to ConocoPhillips and to all of you for coming. And stay safe and hopefully warm heading home. Take care.